Good afternoon, Mike. We're here to go back in a time machine and talk about the origins of Smith Van Gorkom. I believe it was December 1980. Can you tell me about, I know you're a Prickett Jones now and you were a Prickett Jones then. Can you just tell me about what the Prickett Jones firm was like and in terms of stockholder litigation or where this fit in?
Well, you may remember that in 1979, Rod Ward and a number of others had left the firm.
Steve Rothschild?
Ed Welch, and John Small, who later came back, had left and gone over to Skadden Arps. So we had a corporate litigation group that had Bill Prickett and Jim Holzman, then John Small when he came back, and myself, and I guess Vern Proctor was very new then. We did not do a lot of stockholder cases, but there were some that would come along, and it was an area that particularly Bill Prickett had developed a real interest in. In December of 1980, I think it was December 17th actually, Bill Prickett was contacted by some lawyers from the Shank Irwin firm who in Texas who represented Alden Smith, who had been a stockholder of TransUnion. That's how the case began for us. The initial complaint was filed only 2 days later on December 19. There are some interesting claims in that complaint, and a lot of that stemmed from the fact that a good part of the complaint was drafted by the Texas lawyers who really weren't that familiar with Delaware practice.
Okay, and also, yeah, right. And also Alden Smith, he had a unique stockholder position in the case, and sort of maybe a unique interest in what bothered him about this transaction, the sale of TransUnion.
Yeah, there was a heavy focus on tax treatment because he had gotten his stock in TransUnion in a stock-for-stock merger where his company had been acquired, and so one of the major effects for him was that because it was a $55 cash price, he was going to have a huge tax bill. So that was an early focus of the case, but really later on it shifted to more the due care aspect and disclosure aspect.
Right. Well, let's take, I guess, one plaintiff's lawyer to another. I mean, let's start with the foundational question. Who paid for this case? Was it, Alden Smith had a lot of shares. Was this an hourly case or a contingent case?
There was, and frankly, this isn't from memory, it's from looking at some things in the file. Alden Smith paid some money toward the case, I think, initially, but it was really fairly nominal, and then largely it was handled on a contingent basis.
So how was that decision made to take the case? Was this who was it up to, and any conception of how long the case would last? It went on for about 5 years, as it turned out.
Well, I think Bill Prickett almost never met a case that he didn't like. So Bill was very enthused from the outset, and I think was probably the primary person. He was consulting with John Small and Jim Holzman and somewhat with me as well, but I think Bill was really the primary driver. And initially the focus was on trying to enjoin the transaction. And there were, as you know, expedited proceedings. And back then, it was a simpler time. Bill walked the papers up the street on the 19th of December and got the chancellor to enter an order for expedited proceedings. And it was only a few days later that Gil Sparks and Bob Payson surfaced as Delaware counsel for the defendants. And then it went forward from there. When you had someone as tenacious as Bill, and he believed in this case from the outset, so we went through the preliminary injunction, and that was unsuccessful. And then very promptly, Bill pushed the case to trial. The trial actually occurred in 1981.
Right.
And he was unsuccessful after trial. And then it went up to the Supreme Court. And it was up in the Supreme Court, I checked back, it's 2 years and 7 months. So that's where a lot of the case was. And there were, I think, 7 briefs filed. There were 3 oral arguments, including the court entering an order for supplemental questions that they wanted the parties to address. And that was a major part of the case. It was in the Supreme Court a very, very long time. And then after the Supreme Court's opinion, it actually settled within about 5-6 months. But yeah, the case wasn't over with the Supreme Court decision.
Right.
It was going to go back, and we were preparing for a trial on damages. And that would have been an interesting further chapter, but ultimately the case was resolved.
Right. And you said Bill was very strong on the merits from the get-go. Is that right?
Oh, Bill, always believed that the law is that which is boldly asserted and stoutly maintained. And he felt that, and Bill was very much a trial lawyer, and I think what really intrigued him was not so much the corporate law principles as the factual record, and how, in his view, how badly the board had performed, particularly in the first meeting, and then the second meeting, and then with the help of Bob Payson and Gil Sparks, they tried to go back and fix it, and I think
Right.
they could, at least to the majority of the Supreme Court, they never fixed it to the satisfaction of the court, and certainly not to Bill's satisfaction.
Right. So when you say right, boldly asserted and stoutly maintained, so part of what we know about Bill's thoughts about the case were an article that he wrote after it was all over. So this is, I think it was a special issue of the Delaware Journal of Corporate Law in 1985, just devoted to TransUnion, which was, of course, was a landmark historic case, controversial. And what's funny to go back, to read that article, is Bill Prickett saying it was just adamant that the law was clear from the get-go. There was no new law to be made. He says, in TransUnion, the court relied entirely on existing Delaware law imposing the duty of care on Delaware directors. There was no necessity of getting the court to reverse or modify existing Delaware case law. And then to your point about the facts, he says the challenge was to build a factual record showing that the directors had been grossly negligent. And I think one thing we see from the beginning of the court papers is this insistence that there's a basic principle of law that his whole case is going to be tied to.
Yeah, and it's interesting when you go back and look at things, because a lot of the defense was based on, these directors were people who had been CEOs of companies, and they were solid citizens, and Van Gorkom had been at the company for 25 years, and so the emphasis on that side was, well, all you had to have was a collection of very qualified directors and some managers who were experienced with the company. But the specific issue was the decision to sell the company. And that was not something that Van Gorkom had never done a transaction of this size, and the others really hadn't. And I think Bill's view was that you had to not just be competent, you actually had to bring that competence to bear on the particular decision and have the information that was necessary. And for example, he felt that Van Gorkom may have known a lot about the company, but he really didn't know what the company was worth as a whole, which is a different thing
Right.
than knowing the individual parts.
Well, I wonder if we go back to the very beginning, because I suppose when the case walks in the door, when Mr. Smith and the Shank-Irwin folks from Texas first call Bill Prickett, Prickett doesn't know anything about the facts of how the deal was deliberated over, at the board meeting. That comes out in the expedited discovery. So the initial theory was, I guess it was a little bit of a mishmash of theories about why this was a problematic transaction. Some of which talked about was based on Alden Smith's his personal tax situation, right?
Yeah, and you also have to remember, going back to that time, the amount of information that was available publicly was very limited. You didn't have an internet. You didn't have Edgar, where you could go and readily look at the various SEC filings. Now, there were particular SEC filings that had been obtained, and they're referenced in the complaint. But your universe of information starting out was much less than what you'd have in evaluating a case today. And you were much more dependent on getting discovery.
Right.
And the discovery was much more limited than it would be today. Bill sometimes invented funny documents, but he
What do you mean by that?
He put into the record in Smith v. Van Gorkom a list of all the documents that had been produced by the Pritzker Group. It was like 174 documents. And then TransUnion, and it was like 150-something documents. And that was basically your discovery universe. And then you took depositions. Today, of course, with electronic discovery, you'd have so much more information. And I think it would make it easier to make the case out because you'd have emails with the directors and what have you. So you had to go along and then try to develop the story much more through depositions than might have been the case today.
Right. I guess unless you had people that kept their handwritten notes, you're really at a disadvantage for what they're thinking contemporaneously. Right?
That's right.
I guess the funny thing about the case is that really sort of boomeranged against the defendants, as it turned out, because they had trouble digging up the original draft merger agreement that was shown to the board. And so the had that been emailed all around, obviously that would have been, easily preserved.
And you don't know how it would have ended up cut it, because there was representations about what that didn't contain.
Right.
Well, if you had the actual document, then you'd know what it contained.
Right. So anyway, let's go back to just the very beginning, the original complaint. There, by the way, Alden Smith, I remember the defendants raised an issue that he was a guy who he'd been a short seller of the stock and made a bunch of money and then engaged in some hedging transaction by which he didn't have to pay taxes. And they were saying he was an inappropriate plaintiff because this litigation was just designed to defer his tax liability or something along those lines. And here, by cashing out, he had to pay a lot of tax.
Yeah, that was one of the contentions, and that was ultimately addressed because a second plaintiff came in. And then I think also what happened was when a federal action was filed in Illinois, the defendants decided they much preferred being in Delaware with Chancellor Marvel, who denied the injunction, than to risk being in Chicago. So suddenly they became much more willing to agree that Mr. Smith would be an adequate plaintiff.
Right.
And as it turned out, he did all right by the class, I think.
Right. Well, I think it was about a $25 million settlement. But so in terms of the counts, I guess probably the law wasn't very clear about what the counts would be. There should be no count under Revlon, for example, that they hadn't sold the company properly. So like one of the counts, count 4 is discriminatory tax treatment. Is what we were just talking about, that some people, including Smith, have a low basis in their stock for tax purposes, and many public stockholders would face substantial tax liability under this particular transaction if it had been a tax-free, as opposed to a tax-free acquisition. Count 1 for breach of fiduciary duty does say, under subpart B, the defendant, officers, and directors of TUC, TransUnion, have not made an adequate effort to determine the availability of other potential merger partners who could offer terms more beneficial to the company and the public stockholders. And then the next sentence actually, have not made the officers and directors have not made a diligent effort to obtain a merger on the basis of a tax-free exchange of stock. And I was just wondering, does that bring back any recollection? Was that a sort of a tax-driven claim, or was it a proto, kind of Revlon, like there must be a better deal out there even if it's a cash deal?
Yeah, and it also, I think, came out of a feeling that the board had not really been proactive and had not really tried to get it. The deal came together very quickly, and really it was Mr. Van Gorkom and Jay Pritzker who kind of struck the deal at 55, and then they didn't. It's interesting when you read some of the briefing and all there's reference to market test and all
Right.
of this, things that would later develop, but those concepts were really sort of in their infancy at this time. And the other strong case that you had that had a real influence on the claims ultimately was Gimbel and the whole due care concept,
Right.
that where there was a quick decision, and it hadn't been done with real care. That rapidly became a focus of the case.
So you think that's where the due care focus of the case from the get-go came from?
Yeah.
Okay. So at the time of the initial complaint, the recitation, the background of the facts, as you might expect without discovery and without a proxy statement, was the 8K that was prepared at the time of the merger agreement, a press release, an 8K that came out a little bit later, a 13D, and really just about the basics. And so that from that you had to frame some of these counts and come up with some counts.
Yes.
Now, I think as you said, expedited discovery started off just about instantaneously. So the initial complaint is December 19th. So just 2 days after you say Bill Prickett got the call, and then things really start moving fast. A bunch of depositions, a preliminary injunction hearing the very end of January. There's an amended complaint that's filed after after the proxy material comes out and after some depositions have been taken, and that I think was an effort to flesh out some of what became some of the core facts of the case.
Yeah, and the amended complaint particularly added disclosure claims,
Right.
and again, disclosure. You had Lynch v. Vickers and a few other cases that had focused on disclosure, but the law was a lot less well developed then. But it became, very quickly a central focus because the defendants wanted to use the stockholder vote really as a way to try to cure any defects at the board level, and so then the question becomes, well, is it going to be an informed stockholder vote? The initial proxy statement, I think, was about 75 pages long, and I thought, oh, but when you looked at it, there was about 13 pages of disclosure, and then the rest of it was just financial statements.
Right.
And so, disclosure was a bit different in those days, and they ended up then putting out a fairly detailed supplemental disclosure, and then there was a big issue as to whether that was timely or not.
Right.
And again, you got to take that in the context of the time. It wasn't a situation where if you filed a disclosure document with the SEC, it would be readily and immediately available to all stockholders. So you had a real question about, well, was there enough time for the stockholders to receive and act on the information?
Well, one theme, I guess, it's picked up as early as the amended complaint in terms of the limited disclosure available. Well, there seemed to be no concept of like stockholders should be allowed to, say, perform their own DCF and get a sense of what this company is worth. If I look at the original disclosure claim, or the first subparagraph in a lengthy disclosure claim, the complaint says, the amended complaint says, there was testimony of senior management that the great strength of TransUnion was its cash flow. Van Gorkom himself described the company as a cash cow. A senior vice president said the company is an engine of cash. and this idea, but nowhere in the proxy statement would you have any sense of what the cash flow of the company is.
Right. Well, you have to remember, back in those days, we were still, valuation was still under the Delaware block method. It really wasn't until, Weinberger in '83, I think, that discounted cash flow was accepted as a valid method of valuation. And Duff and Phelps, who was the expert in Weinberger, they were also the expert in Smith v. Van Gorkom, different person, Ken Bodenstein in Weinberger, and it was Milton Meggs in Smith v. Van Gorkom. But the whole DCF concept was still very new to the Delaware courts in that time, and there was the defendants in cases would dismiss it as speculative and what have you. Of course, the reality was that was the type of analysis that people were actually using in deciding, business people in deciding whether to sell or buy a company.
Right, and which the facts of this case really bore out, because the idea was Van Gorkom approaches Pritzker with this idea of, like, if you can buy the company, sort of like this early generation leverage buyout, you can repay the debt within 5 years based on the cash flow or the projected future cash flow.
Yeah.
So that becomes a focus of the case, and then I guess to what you were saying, Vice Chancellor Marvel does disregard the DCF, as I think refers to it as unproven and speculative, which then it could become an appeal issue because Weinberger was decided in the interim. And of course, another sort of a fact the case being known for was the absence of a fairness opinion. So you didn't have an investment bank advising the board about any kind of DCF analysis.
Yeah, I think they brought Solomon in afterwards as part of, sort of trying to put a Band-Aid on the situation and do it sort of after the fact. But at the time the board made the decision, there really wasn't any kind of analysis there. There had been management had done a little bit of work in terms of what they thought you might be able to do with a management leverage buyout, but and that just wasn't always done back then. It was really after Smith v. Van Gorkom that now it'd be rare for a sizable company to do a transaction without having some sort of fairness analysis and fairness opinion.
Right. So so let's get back to January 1981. So what Duff and Phelps was brought in, I believe, as they supplied an affidavit, or there's some sort of like expert report of some sort. Their deposition was taken in conjunction with the preliminary injunction briefing. I was really intrigued to look back at some of the briefs you dug up, where the plaintiff's brief in support of the motion for preliminary injunction, the conclusion's on page 105, and that's on, and this is served on January 29th, 1981. Then there's a plaintiff's supplemental memorandum that with some attachments that's filed on January 30, 1981, and that's a conclusions on page 34 of that. And then there's a post-hearing memorandum, not as substantial, but several pages long. So it was a major effort.
Oh, there was a huge effort, and of course it was done at a time where you didn't have the kind of word processing capabilities that you have now. So it was a lot of work, and it, particularly at this stage, it was very much an all hands on deck effort, and you put it together, and but the outcome was very disappointing.
Right. Well, before we get to the outcome, I was just talking about putting in effort. So actually the names on the brief: Bill Prickett, John Small, Mike Hanrahan, Vern Proctor, Jim Delapaz, in terms of the opening brief. And I think that's like the one place your name appears on the signature block.
Yeah, it's interesting because I was in and out of the case at various points, and we were litigating other things, and I think Jim Holzman and I were very heavily involved in a patent case of all things. And so there were times when Jim and I were involved, times when we weren't. The cast of characters, shifted, but the one constant was always Bill Prickett.
Sure.
And he was really the driver of the case, and just devoted enormous energy to it, and just believed in the case from the beginning.
Right. So the case becomes known as a duty of care case, and going back to what you're saying about the law is that which is boldly asserted and stoutly maintained. We see right from this opening brief on the preliminary injunction, this taking straight aim at this is not a business judgment rule case because there's a lack of due care. And I thought one thing that strikes me is that the principal legal authority that's being relied on in the brief is a couple of law review articles by Sam Arsht about the business judgment rule that had just come out. One is Arsht, Fiduciary Responsibilities of Directors, Officers, and Key Employees, 1979. And then see also an Arsht article in the Hofstra Law Review in 1980, where Sam Arsht from Morse Nichols talks about how a precondition of applying the business judgment rule is that the directors must have exercised due care to ascertain the relevance of the available facts before voting to authorize the transaction.
I believe that contribution probably came from John Small. John is a great transactional lawyer. Didn't like to think of himself as a litigator, but he was actually pretty good at it when he did it. And I think he was the. I'm guessing Bill Prickett probably hadn't read those articles.
Yes. But it is interesting because it's sort of like old school law in a sense, but it's not relying on so much on cases as a first principle of law, as sketched out in a couple of articles by the leading practitioner at the time.
There weren't that many cases then. That's the interesting thing is, and opinions tended to be short because the court didn't have great resources either. So you had unreported opinions and things, but not nearly as many, and they weren't nearly as detailed. So you didn't have as much to go on.
Right. And one thing that strikes me looking at the briefs is how many of the opinions that are relied upon by the parties were issued decades earlier. Even now we look back to like the 80s cases or the 90s cases, but here you're looking back to like the 30s or the 40s or some stray principle of law, which even sounds archaic, about things like constructive fraud or stuff like that, about what it takes to prove a case.
There just wasn't that much available.
But from Bill Prickett's perspective, the law was. He says anybody who thinks this is a radical decision or represents any change at all in the law of Delaware is a mischaracterization reflecting ignorance of what the existing Delaware law was and still is, as he put in his article in 1985.
Yeah, and you should have seen the first draft of the article.
How so?
Well, that's one thing I did do, is spend a fair amount of time cleaning up that article. It was even more strident in its original form, and cited very little law, so I added some cases and what have you. But Bill really had the view that people were blowing it, the effect of the case out of proportion. That it was, a case where you had a somewhat unique set of facts, and that got developed, I think, very well in depositions and what have you, and that to him was the key to it, was the factual record. And then it was just, you had the concept of due care, and you applied that to this factual record. If a board conducted itself in the same manner today, I think you'd have the same results. I think boards are a lot more careful these days and get a lot better advice, and often get advice of Delaware lawyers early on rather than only after a suit gets filed.
Right. People talk about Smith Van Gorkom as the Investment Bankers, Full Employment Act or something of that sort. But in a sense, maybe it's also the Delaware Lawyers Full Employment Act, because one thing that Prickett points out in his article, which was the facts, is that no Delaware lawyer was on hand in negotiating this transaction or advising the board about the transaction.
Yeah, and I think, and then even when you had two of the, the best Delaware corporate lawyers involved, and they tried to fix it, but I think they could never sort of overcome the problem that it had been messed up initially, and any effort to fix it sort of suffers from a credibility problem because now the same directors are claiming, oh well, now we looked at it more carefully and we come to the same conclusion, but it's a little hard to convince a court that they're not just basically covering for themselves.
Right, and just to be clear, what we're talking about is Bob Payson for Potter Anderson on behalf of the directors, Gil Sparks on behalf of Jay Pritzker on behalf of Jay Pritzker, the buyer. I guess had this legal strategy that came about, I guess, in January 1981 to have the board sort of reaffirm or have like this whole ratification defense, a board ratification defense, and then a stockholder ratification defense, saying, well, going back, this all makes sense to us,
Yeah, there was I think it was the Mutual v. Western Union case where that type of strategy had worked, and so they were relying on that to try to fix things afterwards.
Okay. One thing that really comes through, I'm thinking like the preliminary injunction oral argument is really striking to get a sense of, I'd say unorthodox, but maybe a better adjective would be like theatrical and dramatic. Bill Prickett was how he couched his oral argument, where he. The way he made it right from the get-go is he said, I was trying to figure out what to say to the court this morning when a stockholder called me up last night and asked me about the case, so I told him about it. And then the argument consists of just dozens and dozens of pages of then, so I told him the facts of the case, and then the stockholder asked me this, and I answered that, and the stockholder has all these follow-up questions. Well, how can that be? How can that be? It reads like a bit of a play.
Bill could tell a good story, and in a way, he ultimately that's what was successful is the story of how did Van Gorkom and Pritzker reach a deal? What did the board know and not know? And that was Bill. I was struck in one of the Supreme Court arguments. He starts out by telling the court things that he's not going to discuss,
right.
and the Chief Justice Herman says, so like Cicero,
right.
You're telling us what you're not going to say. And Bill then responds, and now like Plato, I will tell you what I am going to argue. So that was just Bill. He had a way.
I think Bill Marvel had a couple of classical allusions in sort of his remarks from the bench looking back at these arguments.
Oh, yeah, the Chancellor was again, these were sort of Renaissance men, and they would make these classical references, Bill was always entertaining, and he just had a series of phrases, and could also just come up with things on the spot.
Right, and there's one colloquy, I don't have it right at my fingertips, where the justice asks Prickett at oral argument. He says, "Well, have you thought about this?" And I'm forgetting what the "this" is. And Bill Prickett says, "I've scarcely thought about anything else." But like whether ratification could take effect or something like that. Just to get a sense of the time, and about the law back then, going back to the preliminary injunction hearing. Gil Sparks argues this is an arm's length merger. We've gone through all the cases. And we haven't found a case where any arm's length merger has been enjoined. and the burden of proof is to show constructive fraud by the plaintiffs. And the plaintiffs have their duty of care argument and all the facts about the care, and Prickett's telling this factual story, and there's a question of whether, is there what the roles are and how to characterize Van Gorkom, who he says is a very foolish man. He says they think he was taken advantage of by Pritzker, and just trying to put. Trying to tell a story about how this deal came about and why it's wrong.
Yeah, and it's consistent with the idea that Jay Pritzker knew how to buy companies. He'd done it numerous times before, but so Van Gorkom compared to him was an amateur. That was Bill's view of it.
Right. That's actually charitable. He says about Van Gorkom, I don't suggest that he's a villain. I suggest he's a very foolish man who does a thing so hastily and so ill-conceived, panicking, as he obviously did, that the Young Turks were going to replace the old man who had dominated the company so long. So he had this, his motivational story, but it's not a classic self-interest story as applied to Van Gorkom.
Well, sometimes courts recognize people are maybe motivated by other than financial factors. And Bill always stressed that Van Gorkom was coming to the end of the line, and that this sale of the company would be sort of the crowning accomplishment of his career. But the real question was it the right time to sell this company?
Right.
And he kind of made that decision pretty much on his own.
Right. So what's interesting about this law, it's before 102b7. You have to come up with a story about motivation in some respect, but it's all in support of this duty of care theory that you could apply not just to the preliminary injunction stage, but all the way through trial and for liability. And
102b7 basically came out of Smith v. Van Gorkom.
Right.
It was a reaction to it, and the idea that because after the Supreme Court's opinion came out, then the question was, were these directors going to be personally liable? There was an effort to get the corporate defendants out, and you had a question of would there be sufficient insurance, and would the directors have sufficient assets to satisfy any judgment? And ultimately, Bill concluded that if you were going to settle the case, you really had to settle it with Jay Pritzker.
Well, let's talk about that, because one of the, I guess, great dynamics of the case, or about the lawyering of the case, is Bill Prickett developed this relationship with Pritzker. Isn't that the case? Or
Yep.
Can you just talk about that? Or,
the two really came to like each other, and remember that when Bill went out to Chicago one time, and I think it was for depositions in the case, and Jay Pritzker asked him where he was staying, and Mr. Pritzker wasn't real impressed with the hotel, and said, next time you come out, let me know and I'll get you a room. He was just a very gracious man. Ultimately, one of the things that may have helped was that after trial, Bill actually dismissed Pritzker from the case. Below the opinions are Smith v. Pritzker.
The complaint is right. It's Smith versus Pritzker. Right. It's the lead
and Bill's feeling was that at the end of the day, with all the discovery and all that, Pritzker was just a very smart businessman who saw an opportunity and he took it. And I think that may have been helpful later on when he was the guy you had to settle with. And Jay Pritzker was always very complimentary of Bill, and he said, "Oh, you took this nothing case and you turned it into, you convinced the majority of the Delaware Supreme Court to go along with you." And then it ended up that for years thereafter, Bill and the Prickett firm ended up doing work for Jay Pritzker. And that arose out of the relationship that developed from Smith v. Van Gorkom. And it was basically the two of them who really settled the case. Initially there was a meeting with some of the directors, and then Bill really concluded that if you were going to get this case settled, you needed to settle it with Jay Pritzker. But he was concerned because Mr. Pritzker had some heart problems, and Bill was actually concerned that, well, will he be around? So there was a real interest in getting a settlement done. And back then, Bill was insistent on driving to New York all the time. And one of the things I ran across was New Jersey Turnpike receipt from, I remember going up with Bill and Jim Holzman, and Bill had this old diesel Mercedes, and he kept cans of diesel fuel in the car and driving up and back. And by the time we got back, Jim Holzman and I had decided we were not going on another trip like that because we both had headaches from the fumes. But that was Bill. And ultimately, with some back and forth, and they managed to, I think the ultimate settlement was, I think, $23.5 million. And then there were issues even then with the suit that had been filed out in Chicago. Those folks suddenly woke up,
right? And
of course they thought their suit had brought all this about somehow, even though they basically had been stayed and had sat idle for years. And so they had to be looped into the process, and that was also interesting because the Chicago lawyer was Art Sussman. And while Art wasn't particularly popular with us at that moment, we ended up later doing cases with Art and developing a great friendship with him. So law can make strange bedfellows, I guess it is.
Well, it's the virtue of winning, ultimately, right? Or settling, or winning on liability, and then being able to settle it. So that process was so long from losing the preliminary injunction hearing at the end of January, in February 1981, losing a trial, and then, being all the supplemental briefing and the multiple arguments in the Delaware Supreme Court, and that takes you to 1985. Was there ever a lack of confidence in the case, or a feeling like, oh my gosh, what have we gotten ourselves into?
Well, with Bill, it's always full speed ahead, so he had confidence in the case. And it's you either give up or you play it out. Mm-hmm. And Bill, in both Smith v. Van Gorkom, but also Weinberger v. UOP, which followed a similar course.
Right.
Losing below.
The same years, yeah.
Well, somewhat, but I think the Supreme Court's opinion in Weinberger came out in '83, and that's, while it was a different context, it certainly gave some hope, and there were I think trends developing, but you didn't know, and there are other things where the initial hearing was in front of the Chief Justice Herman, Justice Moore, and Justice McNeely, and then it went en banc, and so you had a sense that at least there was probably one justice who may not agree with the Chancellor's opinion. So you didn't lose hope entirely, but still you felt like you were swimming upstream.
Right. Was there any feeling about how the case, if it went to trial, in terms of was there expected to be some giant payday, or how the prospects for success looked if you took it to trial on damages? No, I mean, first of all, you were going to be taking it to trial in front of the same chancellor who had denied the motion for preliminary injunction. So I think there was some sense that if you're going to win the case, you probably would need to win it in the Supreme Court.
And again, it was a different time. I think you didn't have a lot of successful stockholder side cases where where you were saying, oh, well, there'll be some great fee award. Yeah, the law was very tough, and you hadn't succeeded at the preliminary injunction level, and I think the focus was much more on just trying to win the case,
right.
not expecting there was going to be some great payoff, because it's pretty dicey as to whether you were going to end up with nothing.
Right. I sort of hesitate to say it, but I think that the attorney's fee payoffs were as a smaller percentage than we see now. There was not this concept of getting a full third necessarily.
I think it was. It varied from case to case. Sometimes I don't think the court was quite as rigid as it can be sometimes now. On the other hand, you also have to consider that the size of the settlements, even though they were very large for the time,
right.
They were also somewhat smaller than by today's standards. So that there are a lot of factors the court takes into account in terms of what percentage of the fund it would award. And I think, as I recollect in Smith, you also had the issue of the Chicago lawyers had to get some piece of the fee in order to get them to go along with the settlement. So ultimately, I suppose I don't ever recall Bill being dissatisfied with and I think we were treated very fairly by Vice Chancellor Berger, who
right.
ultimately heard the fee request.
Right. So in the annals of plaintiffs' cases, this was a happy result all around, and as you said, a new plaintiff relationship or co-counsel relationship, and then a new relationship with Pritzker as well.
Yeah. Well, and we also did a lot of work with the Shank Irwin firm in the future as well. So it was kind of interesting that out of that case, there grew a lot of different relationships.
Mike, I was wondering if we could talk about the judicial personalities. And I remember once being said when I was starting out that Bill Prickett wouldn't even care if he won at the Chancery level, because he would try to win on appeal. And I was just wondering if you go back in time to 1980, 1985, whether that would ever be a fair characterization, or what you thought about the odds, or how he thought of the odds before the different judges. Whether a Marvel at Chancery or the Supreme Court.
Well, at the Chancery level, I think there were sort of fewer cases, so you maybe had less of a read. But certainly, you knew Chancellor Marvel very well. He'd been on the bench a good long time, and I don't know that you would have had initially a strong reaction of the chancellor won't rule in our favor, or he will rule in our favor. Obviously, after he decided the preliminary injunction motion adversely to the plaintiffs, going into trial, I think Bill very much had a feeling like, well, you had to go to trial and make your record, but that probably you were not going to prevail at that level. And that doesn't mean that he didn't feel that the chancellor was treating him unfairly or anything. The chancellor was well known to us, and he was always such a gracious man. And I at the time of Smith v. Pritzker, I was still a very young lawyer, and I just remember the chancellor was always very kind to me when, as a young lawyer, I would make mistakes in his court, or do something that was incorrect, and if he corrected me, it was done gently. And he was a very fair man. So I think you thought you'd get, the chancellor's fair decision, but certainly after the preliminary injunction outcome, we didn't have a lot of confidence that you were going to come out of trial successfully. And so you were off to the Supreme Court. And of course, that turned out to be a very interesting process as well, with the court hearing it initially with a panel, and then en banc, and then having supplemental questions, and then having yet another argument. And the transcripts are really pretty interesting, the way the different justices.
Well, Justice Moore certainly had some harsh questioning of the defense counsel, and seemed aghast at some aspects of how this transaction happened. Whether the idea, like, for instance, I remember reading about how keeping secret, Van Gorkom kept secret the negotiations from his fellow directors and senior management, until it was presented to the board that here's the deal, and that I want to see approved.
Justice Moore could be very aggressive in his questioning, and it could vary from argument to argument. And I remember Bill Prickett doing an argument in the Supreme Court, and Justice Moore going after him, and it was about as tough a questioning as I've ever. I think a lesser lawyer would have just sort of shrunk away from the podium and left. Bill stood there and took it, and I think that was something you just learned from the court, that sometimes they'd go after it. It still happens today, and there's aggressive questioning, and I think particularly senior lawyers feel like that comes with the territory, and certainly I think that was Bill's approach to it.
So did he have any feelings one way or the other about the panel or the expanded group, or whether
I frankly don't recall, Joel. It is 30-something years ago.
Right. Mike, I was wondering if you could tell me anything about the appeal strategy that Bill Prickett had.
Well, the thing I remember most is that Bill felt that the chancellor had not gotten certain facts correct, and that one of his strategies on appeal was to first try to convince the Supreme Court that there really were factual errors in the chancellor's post-trial opinion, and that was the first argument in the appeal brief was on factual matters, which is a little bit unusual as an appeal strategy. And then it went into the due care argument and the other arguments, and that was, again, I think, stemmed from Bill's belief that the facts should really drive the case, and if you saw the facts correctly, then you'd reach the conclusion that the board had not made an informed and careful judgment.
That's great. Well, thank you, Mike. I think that's all.
Thank you.